A federal appeals court this week blocked an Alabama law that effectively banned the second trimester abortion procedure known as dilation and evacuation, or D&E. The 11th U.S. Circuit Court of Appeals upheld a lower court ruling which found that the law imposed an undue burden on a woman's right to abort a pregnancy. The American Civil Liberties Union of Alabama had challenged the law. Randall Marshall is its executive director, and in an interview with Capital Journal, he called the court ruling a huge victory.
In a sense, it was a foregone conclusion. When the legislature passed this law, we told them it was unconstitutional. We told them that we would challenge it, and we did. We were successful, and the law has been well established in this area for decades. And it's a waste of time and taxpayer money for the legislature to continue passing unconstitutional laws.
The state is now weighing whether to appeal the ruling all the way to the U.S. Supreme Court. Governor Kay Ivey, who supported the abortion law and who signed it as the former presiding officer of the Senate, tells Capital Journal that she's disappointed with the appeals court striking it down, and Attorney General Steve Marshall agrees with her.
It is just traumatic and it's savage and barbaric to have an unborn child dismembered piece by piece prior to birth to have an abortion. So if we have to take it to the Supreme Court, we just have to take it to the Supreme Court.
We do appreciate the language that was in the opinion. You could tell that from Judge Karnes writing for the majority, and particularly Judge Dabina's concurrence, that they're not satisfied with the current state of the law in this area, but at the same time they had to follow the law, and that's what they did. But we do believe that we'll be able to evaluate what they've written and determine whether or not we will ultimately file for a petition to the Supreme Court to have them hear this case.
The legislature passed the so-called Alabama Unborn Child Protection from Dismemberment Act in 2016.